Please be seated. Good afternoon, ladies and gentlemen. These are public proceedings in the inquiry concerning Judge Gary G. Kreep. I am Justice Ignazio J. Ruvolo, Chairperson of the Commission. All Commission members are present except Ms. Mary Lou Ehringen. Any member of the Commission may ask questions or participate during these proceedings. Respondent Judge Jerry G. Kreep of the San Diego Superior Court is present with his counsel, James A. Murphy and Janet L. Everson of San Francisco. The examiner for the Commission is Trial Counsel Mark A. Lizarraga. This is the time and place duly noticed for oral argument pursuant to Rule 132. Once the argument is concluded and the matter is submitted, the Commission will meet in closed session to deliberate. The Commission's decision will be in writing, and it will be served on the parties and will be made public. Pursuant to Rule 136 of our rules, our decision will become final 30 days after it is issued. The respondent has the right to petition the California Supreme Court for review of the Commission's determination. For the benefit of counsel for both sides and Judge Kreep, the members of the Commission have received the transcript of the evidentiary hearing before the Special Masters, as well as the report of the Special Masters and the parties' briefs. In making your arguments, please assume that each Commissioner is familiar with the record and the issues presented by the briefs. We have scheduled 1 hour for oral argument. Each side is allotted 30 minutes. Judge Kreep, you are welcome to address the Commission as part of your 30-minute presentation. The examiner will be heard first. Mr. Lizarraga, you may proceed. And in doing so, Mr. Lizarraga, I would like to ask you whether you wish to reserve any time out of your 30 minutes for rebuttal, and if so, how much?
Good afternoon. Once again, my name is Mark Lizarraga. I'm the examiner in this case. Mr. Chairman, I would like to reserve 10 minutes.
Okay, 10 minutes reserved.
The factual and legal conclusions by the masters are essentially undisputed in this case. As you're aware, the examiner is contesting 2 legal conclusions. Judge Kreep is contesting 5, although some are legal conclusions, some are factual conclusions. But other than those 7 items, the vast majority of the master's conclusions are not being challenged. Both parties have had an opportunity to brief those 7 issues. I'm prepared to submit it on the briefs. I, of course, will do my best to respond to any questions that you might have as to those 7 matters or any other questions, but I would like to begin by addressing discipline in this case. The Commission has identified several factors relevant to determining appropriate discipline in these types of cases. Again, it's been fully briefed. I'm not going to go into all those different factors, but I would like to highlight a couple factors. And the first is the extent of the misconduct. As you know, the masters sustained 29 charges of misconduct. They found that Judge Kreep committed 1 act of willful misconduct, 16 acts of conduct prejudicial, and 12 acts of improper action. And that was over a 4-year period. As to those 29 charges, Judge Kreep acknowledges some of his misconduct, but the vast majority of the misconduct as to those 29 charges, he does not acknowledge. And that, for example, commenting on the attractiveness of female attorneys that appear in his court, making remarks to a pregnant prosecutor, calling a grown man or a man in his 20s little boy, gratuitously referring to the ethnicity of a female prosecutor, et cetera, et cetera. So the vast majority of those charges he does not acknowledge. The Commission has held...
Excuse me, Commissioner Capozzi has a question.
Mr. Lizarraga, of the 29 acts of misconduct, when did the majority of these occur?
The majority of the misconduct occurred pre-bench in 2012 and in 2013. There were a total of 5 acts of misconduct that occurred in 2014 and 2015.
And when did he take the bench?
He took the bench in January of 2013.
13. So the majority of these took place in his first year or so of taking the bench?
The majority took, well, yes and no. There were a significant number of those happened before he ever took the bench.
Okay.
But the majority of them, yes, happened in 2013.
And the most serious of these is the willful misconduct?
That's correct.
And that's the 170.6 conversation later on?
That happened in 2013 after the prosecution, the city attorney's office in San Diego decided to, I guess, impose a blanket challenge against him.
And you're asking for removal?
That's correct.
Are you saying, in looking at the entire record, there's no salvation for this judge?
I think what you're referencing is that the master's report indicated that he has found an assignment that works for him and works for the court. I was going to get to that later on, but there are several factors that I think require his removal in this case. I mean, I can go into those now, or
Sure, go ahead.
Go into those now, or proceed with my argument. Okay. Well, one of them was the extent of the misconduct. There's 29 charges here. The lack of appreciation. He fails to appreciate the bulk of those, and this court has held that failure to appreciate misconduct indicates a lack of capacity to reform. Also, there's the issue of integrity. Throughout this proceedings, Judge Kreep, in his responses to this commission and in his testimony under oath, lacked integrity. The masters specifically found that his testimony was dishonest. And his testimony that they found that was dishonest mirrors the responses that he submitted to this commission.
All right, we have a question from Commissioner Yu.
I'm sorry to interrupt your argument, but I had a question about how you took the master's statement that they did not believe there was a hostile work environment, and whether or not you agreed with that or not, and whether or not it should be judged by a reasonable woman standard or what, because there was pervasive conduct.
We did not contest that particular finding, Judge Hu.
Okay, thank you.
You know, throughout these proceedings, Judge Kreep has attempted to minimize his culpability. For instance, he has argued that he's been under an unfair microscope, that there has been this campaign of harassment by various groups, one of those groups including this commission. He claims that people were incensed over the fact that he won this election, and so people that supported Garland Peede have tried to get him off the bench. He's also claimed that there has been, I guess, a concerted effort by judges at the San Diego Superior Court. His continued attempts to sort of deflect or to minimize his conduct is really further evidence that he lacks an appreciation of his misconduct here. The next factor that I wanted to highlight, and I've already sort of talked about it, is with regards to integrity. And as I've indicated, the master specifically found that Judge Kreep was dishonest in his testimony in parts. And like I said, that particular testimony mirrors submissions or mirrors his responses to this particular commission. So with regards to Count 1D, Count 1D are the letters, the donor letters that are sent out for fundraising for the USJF. Judge Kreep had testified that they were not public opposition to President Obama's reelection. The masters found that that particular argument was not truthful. They characterized it as disingenuous. With regards to Count 4 is the blanket challenge. That's where the city's attorney's office went in and said, look, we're basically not going to allow you to hear any more cases that we prosecuted based on your conduct here. In response to that, Judge Kreep went over to a different judge's department, as you know, and his testimony was that he did that strictly as a courtesy to inform the public defenders and the interns in that other court that another judge would be hearing their matters later that afternoon. Well, the masters heard and saw Judge Kreep testify, and they concluded that that explanation was, quote, not credible. With regards to count five is the Halloween contest count. That is where this is now Judge Kreep is out of Department 3 in San Diego. He's now in Kearny Mesa Small Claims, and there's a Halloween costume contest. He is in a conversation with an African-American clerk who asks him, who came in third, why third place is no longer awarded any type of prizes. Her testimony was that Judge Kreep responded to her making an offensive racial remark. The masters, again, they saw her testify, they heard her testify, and they made a credibility decision that she was credible, and they believed her and she had no motive to lie. Judge Kreep testified he never made the racial remark. They rejected his testimony and found it to be unbelievable. So that various testimony and the testimony which mirrors submissions to this commission shows that he has lacked honesty throughout this process. The Supreme Court has been clear that honesty is a minimum qualification expected of every judge. Further, Supreme Court opinions have held that few judicial actions provide greater justification for removal than false information to the commission. This particular commission has stated that a person cannot be a judge if they're not honest. Other positive qualities cannot compensate for the missing fundamental. And if there are no further questions, I'm going to stop there and reserve the rest of my time.
All right, you may do so. Thank you. Mr. Murphy, Ms. Everson, Judge Kreep?
No, Your Honor, Judge Kreep would like to address.
All right, very well, thank you.
Ladies and gentlemen, members of the council, I'm sorry, members of the commission, I apologize. Council, my own council. In 2012, I was honored to be elected by the voters of the County of San Diego to be a San Diego County Superior Court judge. In my over 37 years of practice, I had always dreamed of being an attorney. When I took the bench, I thought I was prepared to serve as a judge. However, I was not. I make no excuses. I made mistakes. If you look at the responses and the pleadings that we filed, you'll see that I admitted saying the things the vast majority of times that I was accused of saying. I didn't deny it. I didn't lie. I just did not think that they rose to the levels that the examiner sought to make them. I practiced constitutional law, business, appellate, and family law for over 37 years with no record of discipline. I always treated my clients, the opposition, opposing counsel, and the court with respect. I started my law practice, first in family law, then in constitutional law, to protect the rights of those unable to protect themselves. I've carried that belief system through to my actions as a judge, protecting the rights in court of all parties to the litigation that has come before me, in criminal cases, in civil cases, and in other types of cases. The reality of being a judge, as viewed from the perspective of a lawyer, was much different than the reality of actually being a judge. I know now that there's a totally different mindset between being an attorney watching a judge and sitting as a judge. Coming to the bench, I knew the law, I knew the evidence code, but I didn't understand what it was to be a judge and to do the things that you must do until sometime after becoming a judge, going to judicial council and learning. The first 9 months of my judicial tenure was a very steep learning curve, perhaps the steepest learning curve I've ever had. With regard to one or two things that Mr. Lizarraga commented. I respectfully disagree with the special masters regarding their view of the fundraising letters that I signed while Executive Director of the United States Justice Foundation. The cases that Mr. Lizarraga cited had been going on since 2008, well before I was even thought of running for judge, which did not happen until 2012. I've been involved in a whole number of those cases. Regarding the alleged false statements that...
Excuse me, Judge, we have a question
Yes,
from
sir.
Commissioner Moodian.
Sure. Judge Kreep, thank you for your time today. I'm struggling a little bit with your assertion that this was, there was a steep learning curve during this time. And, you know, in reality, for the very reason that you stated, you were an experienced attorney for 37 years. You had appeared in court numerous times. And just in reading through this and listening to your, and reading through your testimony, when you ran for election and when the voters of San Diego County voted you into your position as judge, is it unreasonable for the public to expect that you would be ready for the job the first day? I mean, we're talking about allegations using nicknames, comments about citizenship, ethnicity, physical appearance, pregnancy of attorneys appearing before you. You know, this is one of the most honorable and important positions in American society. This is the highest level of public service. To me, I'm just struggling. Could you help elaborate on why telling us that there was a very steep learning curve, why that's a sufficient excuse?
Well, you're going to decide whether it's a sufficient reason or not, okay? But let me explain to you. In case you didn't notice, and everybody usually does, I have a rather unusual name, Kreep. And I grew up having to learn to fight my way out of things or talk my way out of things. So I became extremely gregarious. I'm a naturally friendly type of person. When my presiding judge told me to make my courtroom a, quote, user-friendly courtroom, I took it overboard. I really did. He explained that there'd been some issues, that he gave me two directives. Number one, make it a user-friendly courtroom. Number two, cut down on the overtime. So in order to advance both issues, I started trying to become friendly with the attorneys that were appearing before me. And I went overboard. I admit it. I don't make any excuses for what I did. It was inappropriate. But I was trying to deal with a situation where the overtime was 3 to 4 days a week, and I was being told, move the calendar because of budgetary problems. So because I had, for instance, in the deputy public defenders, there were 7 teams of 3 to 4 attorneys each rotating every week. I just couldn't keep straight all the names. I just couldn't. I was not that intelligent. So I would develop visual cues. One woman wore her head in a bun on a regular basis. She testified at the trial. You've seen her testimony. One guy was 6'5". All right, because I couldn't call them all counsel because there were certified legal interns there. In fact, both of those individuals were certified legal interns. I couldn't even call them counsel. I'm not defending what I did. I'm just explaining how it happened. And I was trying to move a very full calendar to get the clerks out of there by 5 o'clock pursuant to the directions. I'm not defending it. It was wrong. But part of it was my own personality of trying to be friendly with people, trying to work with them. Part of it was my taking the wrong approach. And I admit it. As far as the learning curve, having handled the cases I had, coming for judges all across the country, I'd seen so many different ways of judges dealing with things. I saw things that I thought were inappropriate, judges being very abusive, I thought, towards attorneys, and I went too far the other way. I tried to be friendly with them. I didn't try to make friends with them. I tried to be friendly with them so that if they have a question, they could come to me and ask rather than going off on some tangent. And I tried to make myself, if I can give you an example? You're sitting, let's say that, Your Honor, you're sitting at the bench. these tables would be abutting the bench. These tables are pushed up, for the council tables are right against the bench. I mean, it'd be 3 or 4 feet, and I'd hear everything they said. I'd hear everything they were doing. I'd hear everything they said on the phone. I mean, and I tried to be nice and join in on some of the conversations, inappropriately so, but I was trying to establish a relationship with these people so that we could work more efficiently to get the cases done. And that was my error. But it wasn't like I was talking like we are here. They couldn't say a thing. I mean, so you mentioned the pregnancy issue. I don't remember saying the things that I was alleged to have said, but they were talking about her pregnancy, and she was overtly pregnant right in front of me. Okay, it wasn't like I was making up things. So these were things going on about 2 to 3 feet away from me. I'm not defending it. I'm just explaining the circumstances. Did I answer your question, sir?
It's a court of law, and you're referring to somebody's Filipino accent. I mean, that didn't occur to you that was highly inappropriate?
I have no defense for that. There was a series of jokes about accents going on, and I referred to something that had happened to me in junior high school. Completely inappropriate. I do not excuse it. I do not defend it. It happened. I admitted it.
Excuse me, Judge, we have another question from Commissioner Yu.
Thank you so much for that explanation, Judge Kreep. I guess what I'm wondering is, some of what you did was, I mean, it's just a breach of common sense and courtesy on how one treats others, in my estimation. And I'm wondering what you have changed or put into place to ensure that this would not occur in the future, because our mandate is to protect the public. And if the commission decides that you should not be removed, for example, how would we have any assurance that you're not going to breach these common rules of decency that one doesn't need to know to adhere to, whether you're a judge or a lawyer or, you know, or a professor or a teacher? I mean, you just crossed some lines.
I admit that.
How do we know you're not going to do that again? Because part of what I'm hearing you say, and I apologize for interrupting, is that you're saying, you know, I mean, I exercise bad judgment. Well, how has your judgment changed? How do we know you're not going to do this again?
Well, first of all, at the direction of the commission, according to my presiding judge, virtually every tape of every case that I've ever heard since I've been on the bench has been listened to. Okay, and none of these comments happened after that first year. I mean, I could go into detail, but I was told by my presiding judge that they essentially listened to every tape. And I hear about 1,000 cases a month, okay, in UD, and I've been doing that since 2014. If I was doing those such things with various individuals, listening to them to see what else they could find to charge me with, it would have come up in the charges, and it didn't. Okay, that's the best evidence that I can give to you about that. I mean, I was wrong. I was different. I acted in a different way back then, and I understood the seriousness. I respectfully disagree with Mr. Lizarraga that I didn't take it seriously. I did take it seriously.
I'm so sorry. May I ask a follow-up?
Yes, you may.
Have you done any soul searching, any personal education, any counseling, anything to, other than the fact that you can look to a record that indicates you have not stated those words again while you're under scrutiny, but anything that sort of for yourself has changed who you are and how you approach people?
Well, I went through some very hard times in my life, and I won't bore you with the details. Physical ailments, death of a loved one, a lot of stressful things. I've recently become married, but my wife is in the audience, as is my adult son. And my whole life has changed. Now, I've been with that lady since 2016, my current wife, and I had some things go on in my life. Again, I won't bore you with the details unless you really want to know the grubby details. But after I came back from death twice, literally, complete cardiac arrest, I decided that I needed to change my life. And I have moved on with my life and done a lot of education. I've done over 200 hours of judicial education. I've taken every course on ethics that was available to me. I've sought counseling with my peers. Judge Leo Valentine, I don't know if you know him, he helped put Rothman to get the Rothman book together. He's a good friend of mine. He testified for me at the trial. Judge David Rubin, who is active in the state judicial system and who I think many of you know is, I think, the first out gay judge in San Diego. He volunteered to come and testify at my trial to support me, as did Judge Tony Mano, who Governor Brown appointed the first time he was governor, and a couple other judicial officers. Many attorneys offered to come and testify, my UD attorneys and my Department 3 attorneys volunteered to come and testify for me. Some of them did. The trial could have gone for another 2 weeks, and that's not a good use of resources. And I make the point that if I had continued those activities in a venue such as UD, where I'm hearing all those cases, and where obviously there are winners and losers, I think you would have heard from attorneys lining up to testify against me if I was doing those sort of things since I transferred to UDs in 2014. I'm old-fashioned. Excuse the phrase, the proof is in the pudding. But I have changed, and those charges have not been forthcoming since 2013.
Thank you.
Continue.
Thank you. I actually skipped down through some things in answering the question, so I don't want to bore you with repeating things. I was too friendly in Department 3. It's my natural nature. I was too casual. I now know that this is not the way a judge should operate. When I became a judge, the standard procedure was that we would get 6 weeks of training. That had been the way it had been for decades, sitting in different courts around the county. After I was sworn in, I got 3 days. I was put into a criminal department, and I hadn't handled criminal law on a regular basis in decades. The conventional wisdom was that one of the two deputy DAs that were elected at the same time would handle those, and I was requested to be put in civil, or I requested to be put in family, and the supervising judge, Eddie Sturgeon, you may know him, had requested that I be assigned to East County. Ed's a longtime friend of mine. And I was put in a criminal division with a caseload that I had not experienced before as an attorney. So that took me aback, and I struggled to do the best I could, and I failed in many ways. I don't deny that. I have learned from my mistakes. At the time, I did not establish appropriate boundaries between myself and the lawyers who were in that department, but I have done that now. With respect to the blanket challenge that Mr. Lizarraga spoke of, let me give you an explanation of what happened. And this is pretty much uncontested. One of the senior deputy city attorneys, who shortly thereafter left the department, left the city attorney's office, in fact, they lost several senior administrators in a short period of time, came to me to tell me that there was going to be a blanket challenge filed against me. Didn't tell me what it was about, so I kind of had to guess. Just said it was going to happen. There had been a to-do in my courtroom the Friday before between one of the deputy city attorneys and one of the deputy public defenders that got a little testy, shall we say. So I went up to my supervising attorney, and I told him. He had no idea, knew nothing about it, which violated protocol, I was told later, because the city attorney or the public defenders are supposed to notify the presiding judge if there's going to be a challenge. But anyway, I waited up there about 10.
We have another question from
Yes,
Commissioner Moodian.
Judge Kreep, Canon 5A2 prohibits judges and judicial candidates from publicly opposing non-judicial candidates. The masters found that the letters that you had signed as executive director of the USJF clearly opposed Barack Obama's reelection efforts, and you object to the master's conclusion. Could you elaborate a little bit on why you object?
I don't object to it. I respectfully disagree with it. I don't mean to sound braggadocio, but I handled First Amendment cases for 37 years, and I've litigated issues like that. And I mean no disrespect to the special masters, but I don't think they had, from their comments, I don't think they had a great background in First Amendment law. And again, I'd handled First Amendment cases all over the country, and it is entirely appropriate to seek funding for donations to a case. And if you read the whole letter, it's talking about legal actions. It's not saying, help us defeat Barack Obama for election. I mean, I think the letter does mention he's up for re-election, but it doesn't say give us money to that. It says give us money to move forward on these lawsuits. Now, people can disagree with the lawsuits. That's their right. I had clients who came to me and convinced me by showing me evidence that it was an appropriate lawsuit. I didn't file the first of these lawsuits. It was actually filed by a Hillary Clinton supporting attorney back in Pennsylvania. But I was involved in the first lawsuit. I didn't file it. I joined in later in the first lawsuit in California. And again, these lawsuits have been going on since 2008, before the election. Not in my case, but in the Pennsylvania case. So I respectfully disagree with their ruling. It's their right to make the ruling, and it's my right to respectfully disagree with it. I don't criticize them. I just think that they were wrong.
Thank you.
We have a question here from Commissioner Capozzi.
Sir,
Do you think you still have salvation to be a good judge?
I talked to, yes.
Why?
We had a meeting of the civil judges the other day because of the budget cutbacks. We're having to let go 4 more commissioners in San Diego County and 50-plus employees from the clerk sector and related sectors because of the budget cuts. And our current presiding judge, Judge Jeff Barton, was commenting about the substantial caseload I will be receiving on top of what I already have. My courtroom currently has 1,300 new filings every month for UDs in my courtroom. There is a partial UD courtroom up in North County that has 150 a month. That is being ended. All the cases are being transferred to me, so I'll have almost 1,500 new cases every month.
Well, do you think you can handle that caseload?
I've handled the 1,300 cases without any problem. The only cases that have gone out from my department are long cause, because the rule is we don't take anything more than 2 hours, jury trials, for obvious reasons, and 170.6s, because some attorneys don't like me, and there's cases I have to recuse myself on. I've got some friends who own some property in San Diego.
But do you understand that the comments that you have been making in the past that are of issue here, how they're perceived by other people and how it may create a hostile work environment? Do you understand that?
Well, yes. I'm not happy about what I did, but I can't undo the past.
But you understand it now, is
Yes,
my point.
and I admitted, if you look back at the pleadings, I admitted most of these allegations. I disagreed with the penalties being sought, but I admitted most of the violations. I've got a list.
Believe me, I read it, I know.
Okay, so yes, and again, going back to the trial, there were a number of UD attorneys subpoenaed. They subpoenaed one who commented that in his 20 years of courtroom work as a UD attorney, he said, and I'm not trying to sound braggadocio again, he said I was the best judge he'd ever appeared before. They made comments about how I listened to both sides, how I give everybody their time. There were, I don't know if it was at the trial or in other places, but comments have been made about how I try to explain the cases to the people that come before me that are pro-PERS, and we get a lot of those.
So you're telling us that based upon the past experience you've had and what we've gone through, you've seen your misgivings and will change your ways.
Well, I've already changed my ways, sir. Again,
Thank you.
We have another question, excuse me, from Commissioner Yu.
Sorry, just a quick question. I wondered, what percentage of your litigants who appear in front of you in your UD calendar are self-represented litigants?
probably half. I mean, just taking a guess, I never really asked.
But it would be evident, right? You don't have to ask, is the landlord or the tenant's representing himself or herself?
No. I mean, I haven't asked the administration for figures.
Oh, I'm sorry.
Okay, but I'd say half, and a significant number of those do not speak English. We have regular calls for Arabic, Russian, Turkish, Amharic, you name it.
And they're not repeat people usually, right? I mean, the self-represented litigants come one time and then they leave?
Well, we have one gentleman who's had 50 UDs against him, although not all when I've been here. And there's some of the pro per plaintiffs who they represent themselves in these cases. They're on a regular basis evicting new tenants.
Okay, thank you.
We have a question from Commissioner Nishimura.
Your Honor, I've read where you were told to create a friendly courtroom environment, which you premised on the reason why you said what you said to these litigants, these comments you made as part of the reason why you're here today. You've shared with us the accolades that have been presented to the Commission in support of you. You've explained to us that you made mistakes, but I want to hear from you on a day-by-day basis. What have you learned and what do you implement in your courtroom?
Well, first of all, some of the comments that I made were private comments on a side that somebody heard and reported to the Commission. They weren't public comments. The story about the lady that I helped care for a couple of years because of brain injuries, I was kind of a caregiver for her for a while. That was not a public comment. We were talking to somebody after there'd been a case with somebody with brain damage, and so I was making a public comment off the record, somebody inside. Somebody from the city attorney's office heard it, and they reported it, and that's how it got into the Commission records. The comment about we have some attractive-looking deputy public defenders was a comment to an individual off on the side who made some comment about how pretty the women were in the courtroom, and I just responded. That was not on the record. None of the deputy public defenders heard it. I'm not defending it. I'm just saying that's what had happened. It wasn't me saying, oh, golly gee, we've got a lot of pretty-looking girls here, everybody. Okay, that's not me. I wouldn't do that. That's just not my personality. Some of the allegations that were made against me about things that I admitted what I said. I denied what I either didn't say or didn't remember saying. I'm not trying to defend myself this way, but it's 4 years ago, and to be quite honest, I can't remember everything I said in every conversation. But more directly in response to your question, I've erected a wall between myself and the attorneys. That wall is my clerk and my bailiff. Unless there's a chambers conference when both attorneys come into my chambers to discuss a case when they've requested one, I don't talk to the attorneys. I think there was testimony by Ms. Carter, who's an African-American defense attorney in the UD, that she was in my chambers one time with the door open because she was representing the Bar Association in SCRA. Do all of you know what SCRA is? Relief Act. Anyway, it's a program where military individuals deployed are provided with free attorneys. She was the liaison from the Bar Association for that program, and she wanted to interview me, not formally, but to find out what my thoughts were about how the SCRA program was doing in my courtroom, because that's one of the areas where SCRA attorneys are, and I'm sorry, I don't remember what the acronym stands for. Soldiers and Sailors Relief Act, something like that. Anyway, so she testified upon examination of Ms. Laraga that that was the only time she'd ever been in my chambers alone. The door was open. I mean, it was people walking by. I don't allow, the only time that there's ever been a chambers door closed is when I'm having a chambers conference with attorneys about sensitive issues. For instance, sexual molestation, mental issues of a defendant. That's the only time, because then I don't think it's proper for the world to be hearing those comments, and I don't want them out on the record in my UD cases. That's the only time I've ever done that. And so I've erected this wall. I never did that in Department 3 either, for that matter, but I've erected this wall with my courtroom clerk and my bailiff to make sure that I'm not even interacting, except in open court, again, subject to chambers conferences, with any of the attorneys. Does that answer your question, ma'am?
Excuse me, we have one more question from Commissioner Kasparian.
Your Honor, you described yourself as gregarious, casual, and friendly. Others have described you as angry, discriminatory, and improper. Why do you think there's such a contrast in opinion?
It came out during the trial that the reason why the blanket challenge was filed, and this is from the presiding judge at that time, Judge Trent-Acosta, was because the city attorney's office did not like my rulings. Now, they didn't appeal a single one of those rulings. And their own supervising attorney testified at my trial that I did not commit judicial misconduct in any of my cases. But there are a series of memos written by Carolyn Song to the city attorney's office, which neither I nor the deputy public defenders had seen before, which made a number of salacious allegations about myself and them. And Ms. Song had to defend that in court. And the three ladies that allegedly were having inappropriate relationships with me and that were allegedly flirting with me, that were allegedly having 10-minute-plus meetings behind closed doors in my chambers, they weren't just testifying to contradict it, they were angry. I mean, they were seriously angry. Now, I would point out that Ms. Song contradicted some of her own prior testimony at the end. But let me tell you, for her to have seen them in my chambers, she would have had to look through 2 solid metal doors, past 3 wood partitions, across 2 corridors, a bullpen, and into my office, which was on the other side of the building from Chamber 3. So my understanding from a comment made to me by a deputy city attorney who told me if I revealed who said it, she would be punished by the city attorney's office, was that they weren't satisfied with the results they were getting in their cases, so they sent Ms. Song in to bring the hammer down. She was unsuccessful. I continued to rule according to the law and according to the Constitution. And so she got really angry. If you read the testimony of the 4 deputy public defenders that testified, they all said that I was friendly, I was working with them, I was not angry, I was not any of that stuff. That all came from the city attorney's office, from primarily Carolyn Song. I can't explain why she said that. I mean, I have my own theories, but that's speculation.
All right. Thank you, Judge Kreep. Your time is up. Thank you very much for.
Thank you.
Chair, I'm Janet Everson
Yes.
on behalf of Judge Kreep. I do have a few comments, if you would allow me to make them briefly.
5 minutes.
Thank you. The purpose of these proceedings is not punishment, but rather, and I think one of you mentioned it, it's for the protection of the public. And with that understanding, removal in this case is simply not warranted. The examiner's request to remove Judge Kreep is based in significant part, on a contention that Judge Kreep was dishonest, that he showed a lack of candor. It's true that Judge Kreep, he did not admit every allegation made against him, but that doesn't mean that he lied. We have cases adjudicated all the time, every single day, with witnesses who testify to the same circumstances.
We have a question from Commissioner Yu.
Yes. Counsel, sorry to interrupt you, but so Judge Kreep now says he's found the right assignment, but we're supposed to be able to be deployed everywhere. How long is he going to be able to just be in UD and not harm anybody or make any additional comments that are offensive to people? I mean, to me, it just seems unrealistic that he's going to be in UD for the rest of his career.
That's a good question. I think that it's probably unrealistic that he will be in UD for the rest of his career because of all the changes that we're seeing in the court system. But I think what you can take with you is that Judge Kreep has now had 3 years on the bench without problems that were raised in 2013. And Commissioner Yu, I can hear that the problems that you're concerned about are the comments that he made to various people in his courtroom back in 2013. Those comments aren't being made anymore. And the fact that Judge Kreep runs a calendar with so many cases in such a high volume and yet still had witnesses come in and testify that his demeanor and his judicial performance are laudable. One attorney, Mr. Feinberg, testified that Judge Kreep is respectful of attorneys and litigants who appear before him. That doesn't have anything to do with the type of law that he is hearing or the cases that he's hearing. It has to do with the type of person that Judge Kreep is and that he's become over the last several years with all the training and all of the observations that he has made of other judges in San Diego County. So I think that based on the record before you, you can feel confident in deciding that Judge Kreep should not be removed. As stated by the special masters in their findings of fact and conclusions of law, despite the numerous complaints about his conduct during the first year or so as a judge, the evidence suggests he now has an assignment that works for him and for the public. Again, I get that the special masters tied it to his assignment, but we're not talking about the type of case. We're talking about demeanor and credibility. And Judge Kreep has provided 3 years now of exemplary performance in terms of how he is treating people with respect and with dignity. There haven't been any such complaints since when he was in his first department in 2013. And I think if you go back and look at the record, and really try to put yourself into his shoes when he was in that busy courtroom that was so informal before he even got there, that informal environment and his personality together created what was a catastrophe. But now as a judge, he has put things in place to separate himself from those types of informal behaviors, informal conversations. He just doesn't participate. And so when we look at the examiner's request for removal based on a lack of candor or dishonesty, I turn your attention to California Civil Jury Instruction 107. This jury instruction provides for the eventuality that witnesses sometimes disagree about the same events they have witnessed, or they have different interpretations of the same document that they're reviewing. That doesn't mean that someone has lied. Jury Instruction 107 states, two people may see the same event but remember it differently. You may consider these differences, but do not decide that testimony is untrue just because it differs from other testimony. If we didn't have this instruction at the conclusion of every trial where there are triable issues of material fact, we'd all be expecting perjury charges to be filed, and that simply does not work.
You'll have to wrap up. Excuse me, Counselor,
Okay.
you have to wrap up.
Thank you. I guess I'll just close by saying, Judge Kreep has not only addressed in the papers that we've provided to you, but also today in his testimony, coming before you and honestly explaining to you what happened with certain events, the 170.6 challenge. That's the willful misconduct finding by the special masters. That's critical. But that's never going to happen again. Judge Kreep recognizes that he is human, that he has emotions, and sometimes all of us experience being upset, but as a judge, he will not share that publicly. He will not speak to other litigants about it in the future, and you can rest assured that that will be the case. Thank you.
Thank you, Ms. Everson. Mr. Lazaraga? You have 20 minutes left, Mr. Lazaraga.
I'll try not to use that. I just want to address a few things that Judge Kreep had talked about. He had indicated that, that there were lots of attorneys rotating into Department 3, and so that's why he had to come up with nicknames. Well, he didn't testify to that. And with regards to Thang Ho, who was a public defender, he called her Ms. Dimples. He had testified and submitted responses to the commission that he came up with that nickname, not because he couldn't remember her name, because he claimed that he grew up in a black neighborhood and he knew what a hoe meant. And so he didn't, when he called her by her given name, he claimed to have heard snickering and laughter in the audience, although there was absolutely no testimony that when he called her by her given name, that there was any snickering. With regards to Star Parker, again, and that's not, his testimony was not, he couldn't remember her name, so he came up with that. He testified, and other witnesses testified, that he said that she looked like, she resembled a friend of his, a beautiful African-American woman that at one time he wanted to date. And so he just, unilaterally decided to call her by that. It had nothing to do with him not recalling her name. With regards to the Dorner letters or the public opposition to Obama's reelection, by Judge Kreep, even if we assume those letters just evidence this important social issue as they claim, and this constitutional issue, even if we assume that, by his own words, he's publicly opposing Barack Obama, because what he's saying is he is not qualified to be president. He's not a natural-born citizen, therefore he shouldn't be seated as president. But so again, even if you give him that spin on those particular letters, he's publicly opposing a candidate for non-judicial office. But if you look at the letters, I mean, he calls Barack Obama a cheat, a liar, a thug. He claims that he is a socialist, a tyrant, that his policies have been devastating for the economy, the country, our way of life. So clearly, those letters are not just evidencing an important constitutional issue.
Excuse me, Azaraga, we have a question from Commissioner Simpson.
Yes.
Mr. Azaraga, what weight do you think we ought to give to what appears to be the fact that the overwhelming amount of this misconduct was in the first, either pre-bench or in the first year or so that Judge Kreep was on the bench, and that since then there have been few, if any, allegations of misconduct? What weight? And then you heard his explanation about he has gone to a couple of hundred hours of judicial training. He's had some counseling with someone in the court world about demeanor and those sorts of things. What weight do you think we should give that in thinking about the level of discipline?
Well, that raises one of the issues that I was going to respond to, and that is this particular investigation here by the commission ended in 2015. So it would be speculation by me and by this commission to say that, he's been doing fine in 2016 and 2017, because there was, again, the investigation ended in 2015. There was, albeit some general testimony by attorneys that appear in his courtroom saying, oh, he's doing a great job, he's doing really well. But other than that, it would be speculation for this commission to somehow assume or infer that there's been no problems in 2016 and 2017 when this investigation ended in 2015. Additionally, look at his conduct here in these particular proceedings. Has he been candid? Has he been honest? The special masters found that his testimony was not credible, that it was disingenuous. Basically, what they found is his testimony was false. As I already indicated, that particular false testimony mirrors responses that he provided to this commission. So it's not just looking at 2012 and 2013, the couple matters in 2014, 2015. You have to look at his conduct in these particular proceedings. So I think you have to take it all into consideration, and as I indicated, and based on commission precedent and Supreme Court precedent, because of the amount of misconduct, because of his failure to appreciate the misconduct, and because of his lack of candor, he should be removed. So if I answered your question?
Yes.
Okay.
We have another question from Commissioner Moodian.
That said, why would we be doing a better job protecting the public if we remove Judge Kreep versus a less serious form of punishment?
Well, it's not just protecting the public. It's enforcing rigorous standards. It's maintaining confidence in the integrity of the judiciary. And you have to think of the power and the solemnity of the oath. And when you have a judge that doesn't honor that oath, why should he be in a position to judge witnesses' credibility? And I think really, frankly, given Supreme Court precedent and based on that fact alone, he should be removed. If I have a couple more minutes, with regards to him claiming that there's been no further misconduct and I've already changed my ways, I've already addressed this. In this proceedings, has he changed his way? Did he respond truthfully to inquiries by this commission? Did he testify under oath truthfully? Again, he persists with this lack of training argument, which really is evidence that he fails to appreciate his conduct here. You know, instead of owning up, he's always trying to look someplace else to explain his misconduct. The master specifically found that he received adequate training here, if not actually more than a new judge. And just look at the conduct in count 2. Do you really, what kind of training do you need to tell you not to do those things? I mean, do you really need someone to tell you don't adopt pet names for female attorneys that appear in your court? You know, don't comment on the attractiveness of female attorneys that appear in court. Do you really need training for that? I mean, he was a judge he was an attorney for 37 years before he became a judge. It should have been readily apparent to him that that conduct in count 2 was inappropriate. You know, if there's no further questions, I'll just conclude and say that the legal system depends on public confidence in the judiciary. And when you have a judge who has committed multiple acts of misconduct, as Judge Kreep has done here, when you have a judge who fails to appreciate his conduct and continues to deflect and insist that fault lies somewhere other than with him, who responds falsely to inquiries by a judicial commission and who testifies falsely under oath, the only viable option to maintain public trust and public respect in the judiciary is to remove that judge from office.
Thank you, Mr. Lazaraga. Thank you, Ms. Everson. Thank you, Judge Kreep. The matter is concluded and we are adjourned.